party members, we are affiliated in one way or the other with one party or another. And all of us, except possibly one or two parties, are all supportive of government reform, of government program. Does that mean that the entire impeachment court is biased and partial? There is no other interpretation I can read into these actuations of the defense, Mr. President, except to destroy the credibility of this impeachment court. I think that's the least that they ought to do, because this could be the saving grace in our democracy. If you destroy the one pillar of justice, the Senate, who can stand up even to the Supreme Court or the President, then you are really knocking down the very pillar that one day you may have to seek help and succor from, because it can stand up to any person or institution. And to see how malicious this insinuation is, Mr. President, in their concluding paragraph, they said, the only way Senator Angara can redeem himself is to vote for acquittal. Mr. President, you know, I've been president of the UP, I've been president of the Integrated Bar, I've been president of the ASEAN Law Association, I've been honored by all of these organizations in various ways. I've never seen logic or legal logic like this. And therefore, Mr. President, I take umbrage at this malicious paper. My good friend Joker, when I showed him the petition yesterday, he said, Ed, don't answer it. It's not worth it, because you are doing a constitutional duty. They don't seem to appreciate that. And yet Joker is very sympathetic, and I can share his feelings towards the cause of the defense. So you see, as of now, but after this, maybe not anymore. So, Mr. President, I don't know. I have one outstanding alumnus of the UP College of Law, very able, very skillful, very eloquent, and can stand up in argument head-to-head with anyone. But he has one outstanding trait. He has a penchant for antagonizing the judge. So no client will now retain him. Because what's the use? You may have a good cause, but if you antagonize the judge, your cause is lost. No, I'm not comparing our set of defense, our panel of defense, to that one friend of mine who's brilliant, knowledgeable, eloquent, but has a penchant for antagonizing the judge. Thank you very much, Mr. President.
Thank you, Senator Angara. The chair would like to state for the record that we respect the opinion of others regarding each one of us or all of us collectively. But I assure you that none of you can sway us one way or the other. And if you have any reason to believe that we are dishonest, say so candidly and openly. And we are ready, willing, able to defend ourselves. So let us forget about this sad incident. Let's proceed with the case. Defense, present your evidence.
Your Honor, please, with the kind permission of the court, Your Honor. May I be allowed even one or more minutes, Your Honor, to make a little manifestation?
Proceed.
Thank you, Your Honor. Now, there had been some insinuation yesterday that the defense had been trying to delay the proceedings in this case, as evidenced by the fact that we have introduced quite a number of witnesses with no purpose and accomplishment whatsoever, Your Honor.
Who was making the insinuation? Was it from this court or from anyone? Let us be specific.
Well, that seemed to be our impression, Your Honor. that apparently
It was the court?
the defense was trying to delay proceedings, Your Honor.
Are you suggesting that it was the court that created that impression?
No, it came from the prosecution, Your Honor.
Well, that's the prosecution.
Yes, Your Honor.
All right.
And we wanted to be heard in connection therewith. Otherwise, we may be said to have acquiesced to that kind of a manifestation, Your Honor. If the records will be read, Your Honor, we have introduced quite a number of witnesses in connection with our defense, Your Honor. Some of them, they consist of 3 register of deeds, Your Honor, 3 assessor, city assessor, and provincial assessor, Your Honor. Insofar as the register of deeds is concerned, we introduce them for the purpose of showing that there are no properties aside from those mentioned in the SAL, Your Honor, of the Honorable Chief Justice that belongs or were registered in his name. We cannot lump up only one testimony or only one register of deeds because the properties were located in different places. So, if we presented the register of deeds of Makati, of Manila, and Quezon City, it was never our purpose, Your Honor, to gain time in order to delay the proceedings, Your Honor. Not even the thought of it, Your Honor, but because we cannot do so. The register of deeds of Makati will be highly incompetent, Your Honor, to testify in connection with the records of the office pertaining to Quezon City and Manila and vice versa. That was our purpose, Your Honor. And we also introduced in evidence the testimony of the administrator of the Land Registration Office. From these statements obtained from them, Your Honor, on record, we were able to show convincingly, Your Honor, that the 45 real estate properties allegedly referred to be registered and owned by Justice Corona, Chief Justice Corona, Your Honor, does not all belong to him, but only 5 of them. Hence, it cannot be said that our purpose was merely to delay because apparently we could read from the records that even the court was convinced that actually there were only 5 or 6 properties that really belong to Chief Justice Corona. Now, how about the testimony of the various representatives of the assessment office, Your Honor? Now, we admit, Your Honor, we introduced 3 assessors, Your Honor. The city assessor of Makati, the city assessor of Manila, and the city assessor of Quezon City on the same ground, Your Honor, because we cannot make one of them testify for the entirety of the properties not located in the respective places. So, if we presented 3 assessors, Your Honor, I hope we will not be misunderstood as trying to delay the proceedings, but it is because of our recognition that one is not competent to testify as to the other and vice versa, Your Honor. Now, thereafter we went further, Your Honor. We introduced in evidence the testimony of Ms. Araceli Bayugan, Your Honor, the finance officer of the Supreme Court, Your Honor, in order to belie and contradict the statement on record that there was no statement of returns of income tax return, Your Honor, made by the Honorable Chief Justice Corona, Your Honor, because from the testimony of the Honorable Commissioner of Internal Revenue, there were no returns, Your Honor, in arrest, Your Honor, for the years 2005, 2006, 2007, 2009, and 2010, Your Honor. We were able to introduce the returns, Your Honor, identified by our witness. They were duly marked. We took note of the trouble of marking the...
We know, counsel, we know all of that. It's all in the record. We are not accusing you of delaying.
Thank you, Your Honor, because that was our impression, Your Honor, that we introduced these witnesses simply because to gain time, Your Honor. That's why we are placing on record
I must admit that yesterday I said you are wasting the time of the court by introducing someone to testify or whether market fees are being collected from that market.
We are not in conformity with that, Your Honor, but the plan of the other lawyers came up, Your Honor, and we allowed him to take
Well, then you better advise your other panel that Those things are irrelevant. We know what is an irrelevant evidence.
We did, Your Honor. In fact, I gave him a tongue-lashing yesterday for the correction of all these matters that gave rise to the impression of the court. That is our only purpose, Your Honor.
All right.
Now, to contradict that and so on. Now, insofar as the Land Registration Commissioner is concerned, Your Honor, we called him to the stand in order to testify on the various alleged properties which he ascribes to be belonging to the Chief Justice. And we were able to elicit admissions, Your Honor, to the effect that they were not properties registered in the name, specifically in the name of the
already
Chief.
given, Counsel.
Yes, Your Honor.
In fact, yesterday when Congressman Colmenares of the prosecution was asking for made a manifestation, the tendency of which was to reconsider the ruling of this chair on the claim that it will only prolong the proceedings. I denied it. So you can see that we are giving you all the time to defend the Chief Justice. We know that you are entitled to defend the Chief Justice. So
And
the impression or statement of the prosecution is their position, but that is not the position of this court. That you are delaying. That's why we are asking you to wind up your manifestation so that we can proceed with the hearing.
Thank you very much, Your Honor, for the opportunity for being allowed to bring all these matters into the record in order to straighten at least the intention, the impression that may have been created, both public and upon the other parties involved in this case, that we were trying to delay. That was never our intention.
All right.
Now, in connection, Your Honor, with the motion for inhibition, Your Honor, the motion was filed because of the feeling of the Chief Justice that at least he may not be able to obtain the recalled neutrality of a judge insofar as the subject of the motion is concerned. Now, what we did was to file it is up for the... We never stated that everything stated thereon are indubitably true, Your Honor. But we wanted to express, to give importance to the feeling of the Chief Justice in order that if a decision is made one way or the other, there is no doubt as to the impartiality and lack of bias on the parts of the deciding member of the Senate, Your Honor. Thank you very much, Your Honor.
Well, thank you for your manifestation.